This is another iRaw podcast. We podcast to make the world a better place for animals.
Dr. Siobhan O'Sullivan does like knowing animals. Dr. Siobhan O'Sullivan does like knowing animals.
Hey people, welcome to Knowing Animals. Knowing Animals is a podcast where we speak to animal studies scholars about a piece of their work. I'm Siobhan O'Sullivan and I do like knowing animals. Well, this episode of Knowing Animals is brought to you by the wonderful people at ASA. ASA is the Australasian Animal Studies Association. I'm a member of ASA. Are you a member? Membership is just 15 Australian dollars. People can become members. For the unwaged, $60 for the waged. People can become members from anywhere around the world, and those membership fees help support the organisation that does a lot of work to support animal studies scholars, including organising a conference every 2 years. God willing, we'll be able to have our conference as planned next year. So think about joining and supporting ASA, the Australasian Animal Studies Association. This episode of Knowing Animals is also brought to you by the wonderful people at Animal Publics. Animal Publics is a book series that sits within Sydney University Press, and it is a book series that is specifically curated to bring forth the latest in animal studies research, but also poetry, other kinds of storytelling. It's a really diverse series, but what unites it is a very positive focus on animal issues. So it's a really wonderful one-stop shop to get the latest in animal studies publications. And it's also a good place to keep in mind if you have a lazy manuscript lying around and you're wondering who to publish it with. I suggest that you think about adding the people at Animal Publics to your shortlist. Okay, well, let's get down to business. So this is another episode of Knowing Animals that's being recorded in the time of COVID-19, but it is also, as we've already said quite a few times, an absolutely wonderful opportunity to get guests on this show who perhaps I would not have been able to be, who I wouldn't have been in the same room with, in the same city as for many years. And so this has opened up the suite of guests I can have. And the guest I have this week is someone who I've known very well for a very long time, but also someone who lives in Canada, which, as we know, is a long way from Australia. So this week we're joined by Peter Sankoff. Peter is a member of the law faculty at the University of Alberta in Canada. He's also Associate Dean. And today we're going to discuss Peter's paper, Canada's Experiment with Industry Self-Regulation in Agriculture, Radical Innovations or Means of Insulation. And it appeared in the Canadian Journal of Comparative and Contemporary Law in 2019. Welcome to the podcast, Peter.
Pleasure to be here, Siobhan.
So, Peter, what inspired this work?
Well, I've wondered a lot about regulatory frameworks involving animals for quite some time, and it's sort of been a theme of my scholarship that one of the biggest problems we have in managing the human-animal or non-human animal relationship for quite some time. And there's always been a concern that one of the biggest problems, especially insofar as agricultural animals are concerned, is that the means by which we decide to regulate these animals is flawed. And in many cases, as we know, there are situations where there are no regulations whatsoever. At least that was the framework for quite a long time in most countries in the world, including Canada and including New Zealand, where I used to live. It's only in relatively recent times, say the past 20 years or so, that we've decided to regulate at all. But what's happened in this regulatory relationship relationship is somewhat interesting in its own right. So for a long time, it was that the problem was that we didn't regulate. But what became an interesting sideline is that in situations where we did decide to regulate, the question was, well, how did we decide to regulate? And that in and of itself is sort of an interesting question that I started to look at, because notionally, the law governing animal-human relationships is criminal law in the sense that it is an offense to, ill-treat or commit cruelty against an animal. But the manner by which animals are kept by large agricultural industries or corporations is a little bit different in the sense that they are holding large numbers of these animals, and it's very difficult to use the criminal law as a tool to sort of investigate or make sure that the animals are being well treated. So this sort of gap in the framework, in the sense that animal treatment wasn't being regulated, led to the rise of these sort of self-reporting regulatory regimes, and the idea that the industries were sort of regulating themselves. As you can imagine, this was not a very efficient way of doing things. Anytime you let industries regulate themselves, it usually doesn't end up being that good for the people or the animals or the interested parties that are subject to that regulation. And I think what ended up, after there were many cries about the illegitimate nature of these things, there started to be a pressing need for something new to come into being. And what happened in Canada is that although the industries resisted regulation, they realized that the absence of regulation was sort of a perceptual problem. Because what happened was, every time, you had protesters or animal advocates or activists who were exposing mistreatment on farms, the cry was that there was no regulation on these farms. We've got no regulation, no government oversight. So what happened was the farmers seized on to the idea that rather than be regulated, maybe it made more sense to regulate themselves. And that's what they started doing. They started creating these industry frameworks whereby, within individual industries, they would set up these regimes that were certainly not regulation. They had no legal force, but they were sort of guidelines or standards. And then to make them look official, they would, be group standards, not just individual farms. They would have group standards from, say, the pig industry or the dairy farm industry or whatever. And as they started to do this, they started to lobby the government for quasi-official status. And amazingly, at the turn of the 21st century, in the early 2000s and moving through to 2010, they got that status. They actually managed to create a body called, in Canada, the National Farm Animal Care Council, which is essentially an umbrella group of industries with a couple of, other groups thrown in. And amazingly, they, through lobbying power, managed to get the whole thing funded by the government. And essentially what happened was they've created a body that now creates standards, not laws, because they have no lawmaking power, but they started to create these codes of practice. And these codes of practice are sort of these, unofficial, sort of official standards that you have to adhere to, but it's not clear why. And I, as a law professor, was very interested, both in terms of, I was interested in what it meant for animals, but I was also interested in what it meant for the law. Like, what does it mean when you create these quasi-official, unofficial standards that kind of have the blessing of government, because government funds the group that does them? And if you look at these things, they're very glossy and they look like very serious publications with recommendations and, official standards that have to be met. And yet nobody has any idea of what their legal status actually is and what happens if people ignore them or don't apply to them. And moreover, forget about ignoring them and complying with them. What does it tell us about the public lawmaking function when these standards are created by the industry groups that are governed by them? Like, what does that tell us about the legitimacy of the status that they're sort of conferring to these standards that are supposed to be, progressive considerations of animals' health and welfare? So I just found this a fascinating topic in terms of its, the way in which what it meant or what it says about the law. But I also found it really important for someone to take a look at this and say, well, what does this mean for the animals? Like, that these standards exist? Because, we've been saying all along, there's a real battle amongst advocates and industry groups. Whenever advocates are asked about the situation in Canada on farms, we say there are no laws. And when you ask the industries about whether there are laws, they say, no, we have these NFAC codes. So there's a real battle of public legitimacy about the meaning of these codes. And I just thought that had to be explored.
Wonderful. Well, Peter, there's a lot in that I want to ask you about, but can we take a step back? Your article opens with a fairly damning critique of Canada's comparative animal welfare standing, or the extent to which it has animal welfare laws that are developed and working compared to other comparable nations. Can you give listeners a little bit of a sense of what animal agriculture is like in Canada and the kind of legal framework that existed before the establishment of the NFACC?
That's really straightforward. That won't take very long. It's comparatively, agriculture has a big place in Canada. I don't think, as you know, I worked in New Zealand for 10 years, and it's not quite as substantial. It doesn't have the same standing or the same percentage of the, gross domestic product of the country as it does in New Zealand. But there's no question that we're an agricultural nation here, and we have a huge dairy industry, a huge, like everybody else, every country now has a huge chicken industry, eggs, beef. We produce all types of things. So we are an agricultural nation. And I'd say it's certainly agriculture plays a bigger role in Canada than it does in Europe. But I'd say a lesser role animal agriculture plays than it does in New Zealand. I'd have to think about Australia. I think it's probably comparable to Australia. So I think in that sense, it's pretty straightforward. It plays a big role. Telling you what the rules are before these codes came into place, because my view is the rules are exactly the same even when these codes are in place. We have very little oversight of our animal agricultural industries, with the exception, of course, with respect to, say, biosecurity, where we actually have a very robust oversight regime, because we want our food chain to be healthy, as it were. But in terms of like what's the oversight role in terms of law, it's very straightforward. We have, from what I can tell, no law that directly governs the way in which animals are treated, with the exception of two areas in which the federal government has taken responsibility. One is transport and the other is slaughter. The role at slaughter, I think, is partly because of the concerns about biosecurity. And if you look at the law that governs slaughter, most of it is surrounding concerns about biosecurity and obviously making sure that slaughter is done in a way that keeps the food product safe for consumers. But there are a few legal standards in the law that are designed to be animal welfare friendly. So the federal government, I can't say that there are no rules around slaughter. There are. The federal government has also taken a role in transport, and there has been a role in sort of, limiting certain excesses in transport, though, we could have a long debate about how well these work and, how well they're actually enforced. But there are rules around transport. And that's it. The reason for that is we're in a federal system here. So the federal government has a national cruelty law, but that is effectively for malicious acts of cruelty. It has really never been used in the farming context. And while I think there's a case to be made that technically it could, it's really not worth talking about because it doesn't really provide any real oversight. That leaves the provinces, and the provinces do have laws governing the way in which the animals are used and kept to a certain extent. But all of them just have one big fat exception, which says that anything done in accordance with generally accepted or reasonable agricultural practices are exempt from the Act. So as a result, unless you have farms that are essentially, I've always referred to them as apocalypse farms. The farms are sort of, they're going under because the farmer, doesn't have the means or the ability to keep the animals healthy. In those cases, we do see prosecutions, but in terms of actually regulating or monitoring or even legalizing or making certain practices illegal, our provinces have decided to stay by the sidelines. So to be honest, it's essentially whatever the market will bear. There are no restrictions. The only thing I would say about that is where farmers engage in practices that are clearly unreasonable, like they adhere to practices from like 50 years ago and keep animals in ways that is clearly unreasonable, you could get a prosecution under the provincial laws. But again, if we're talking about setting legal standards to govern the ways in which animals are kept, we just don't have any. And that's true even with the codes, in my opinion.
Fascinating. Well, I guess the other side of the animal protection coin is, of course, what animal advocates are doing. And you've pointed to the concept of social license, a few times in our discussion and also in the paper. So to what extent is the animal protection movement in Canada active on agricultural issues, and how much of this self-regulatory framework is a response to pressure applied by advocates?
I think a lot. I think that's fair. I think the idea is that I believe in every jurisdiction, quite frankly, where progressive laws have come in. And I don't want to say that, the farming industry or the agriculture industry has no interest in creating standards of itself or its own, for its own reason. But what my study of the law has been is that in just about every jurisdiction where new laws or new regimes have come in, they've come in at the instance or at the initiative of the industries. That's certainly the case in New Zealand, and it's certainly the case in Canada. But the reason why the industries have done that is that they've recognized that the absence of a regulatory regime causes more pressure. Like that's always been the case in any jurisdiction that doesn't have a law. If you can just go and say there's no law, well, that's the biggest problem. And the anytime there's an excess, that will look very bad on the industry. So I do think that the animal advocacy movement has been a big factor in obviously getting change to occur. And I think that it's interesting that we're at a time right now when these new laws or these new rules are supposedly coming into force at the same time as the governments in several parts of Canada are doing everything they can to shut down the ability of protesters or advocates or whatever to highlight what is going on farms. We are now instituting the first ag-gag style laws in our jurisdiction, and they've been designed deliberately, I think, to shut down these types of revealing what is actually going on farms, to show that the standards are just unacceptable.
Well, Peter, in your article, you point to some possibly good aspects to this self-regulatory system and these kind of quasi-legal codes. Can you tell us what you think are some of the good aspects to what's happening in Canadian animal protection law?
Well, they are limited good aspects, let me say. I think that the good aspects are outweighed by some of the problems, but there's unquestionably good aspects to any regulatory framework. Keep in mind that the absence of a regulatory framework is, in my opinion, even more problematic because I have a saying, and I repeat it many, many times in many different contexts. I say that animal cruelty lives in ambiguity. The more ambiguity there is, the more cruelty there is. And the reason for that is that as vulnerable beings, animals are dependent upon protection from others. They have no ability to exercise that protection for themselves. So the more ambiguity there is in the way in which animals can be treated, the more that I think cruelty will flow to fill that ambiguity. So when you say, as I said earlier, that the only standard in Canada is whether the practice is generally accepted or reasonable, I think that's an absolute disaster for animals, like far worse than any regulatory regime I can dream up. And the reason for that is, as bad as I think the NFAC codes are, at least they put in standards that I can point to and say, okay, like they talk about things like, for example, battery hen cages. And I think they say ridiculous things about them. And I think they, don't respect, the way in which the animal's health should take precedent and the ability to move around, et cetera, et cetera. But at least there's a standard that's measurable. At least I can say, well, that standard doesn't make any sense, and here's why. And I think the problem of ambiguity is such a big one that we have to be careful about, wishing away codes. My belief is that codes are just about the only way to, in the short term, barring more radical change, to develop anything positive for animals, because I'm never a big fan of general standards. I don't think they'll work. And then the other thing I was going to say that I think is good about codes, to me, the most beneficial feature is that given the many animal uses they are, and this ties into another article that I wrote in 2012 about lawmaking as a form of political discourse or social discourse. And I adhere to the view that I expressed in that article, that the animal-human relationship is so complex, and it's spread across so many realms, and there's so many different angles of it, that the truth is, when we advocates are trying to explain this to members of the public, it's almost like there are just too many things for them to understand. And it's just like, I can say animal use bad. Well, if they don't want to hear that, and, most of them don't want to hear that, they want to get some understanding of what it is. The problem is that the fight's too big. It's too big to bite off. So for me to go after a law that attacks all animal uses is just very difficult to do. What I think these codes do is, the only thing I like about them really is that because they have to be perpetually reenacted and replenished, what I've noticed is they provide a sort of I don't think this was their object, but I do think they provide a way of staggering the political discourse around certain animal uses. And it's very interesting that I was just looking in New Zealand, for example, where farrowing crates is back on the agenda, which is really interesting because when I left there about 10 years ago, farrowing crates had just gone off the agenda. It was too big a problem. Well, the fact that these codes need to be renewed consistently and revisited means that animal uses are constantly being put back on the agenda. So in the Canadian context, as critical as I am of the codes, and I'm very critical of them, their existence means that there is a body that is studying these particular uses on a sort of quasi-perpetual basis. They're always studying different aspects of the animal-human relationship. So every 10 years or 15 years, they have to revisit one of these codes. Now, I don't really think what they do is that progressive, and I don't really think that the groups themselves, actually are going to change things in a measurable way. However, since these are at least, largely public debates, the staggering of the code enactment process provides for a more bite-sized discourse. So this year we're going to get chickens, and next year we're going to get pigs, and then we can explore different aspects of that. And I do think that's a little bit better than sort of having this broad-based animal law, which almost never gets revisited. I mean, in the province that I'm in, ours hasn't been amended in 20 years, and there's no legislative appetite to amend it tomorrow or next year or the year after. But the codes provide at least a means for me as an animal advocate group to say, okay, they're reviewing the pig code. Pick one just out randomly. Let's talk about pigs. And that has happened in Canada, even though we all recognize most animal advocates don't really have a lot of time for the code process. I don't deal with it in a particular way, but it does provide for media discussion opportunities about particular animal uses. And I think that in and of itself has the potential to drive the discourse forward, hopefully in a positive way.
Interesting. But as you, of course, have just pointed out now and also in your article, there are plenty of aspects of the system in Canada that are problematic, not least of all the composition of the council. Can you say something about the problematic aspects that perhaps you've not touched on yet?
Yeah, sure. I mean, the numbers thing is always the easiest for people to wrap their heads around. NFAC is just, if you go read all the NFAC documents, all they want to talk about is how wonderful they are and how this is a pro-animal organization and all about consensus, and we're reaching conclusions based on consensus and consensus and consensus. And they talk very loudly about that, about bringing all the stakeholders together. But when you dig deeper and you look at what they mean is they want to bring bring together all the stakeholders across the animal use spectrum. So when they say we want to have consensus, what they mean is we want to have consensus between the farmer and the slaughterer and the transporter and the restaurant and the whoever else they can think of. Like, they have so many groups that are associated, but when you go and look at it, it's always huge numbers, massive, overwhelming numbers of groups that are involved or directly have a profit stake in this exercise. Now, thankfully, and in my opinion, unthankfully, they are bolstered by just enough critical voices that they can legitimately say, well, it's a full discourse thing, because the Canadian Federation of Humane Societies believes, mistakenly in my view, that we're better off in the system than outside of it. So the Canadian Federation of Humane Societies is a member, and so are a few governmental organizations and a few veterinary societies. But if you look at like every code they've ever drafted, as well as the NFAC executive, the numbers are mind-boggling. Like, it's always like way more than half of our industry people, and like the industries that are most affected are always dominating the committees. So in terms of every decision they make, from the executive all the way down to the actual committees, the numbers are dominated by the producers. And I would just point out that they're very clever. These people, the people who put together NFAC are not stupid people. They're very clever. You can't go on NFAC unless you adhere to their principles, which is use. So essentially, they like a group like groups that I belong to that are anti-animal use cannot get on. And more importantly, if you do get on, there are no dissents allowed. They don't allow dissenting opinions on the reports. It's all got to be consensus. So as a result, you've essentially neutered the ability of like the biggest organization in Canada, the Canadian Federation of Humane Societies. Now they're on side. So as a result, like, they can't criticize anything that comes out of these codes. Even if they disagree with it, they're stuck. So it's like, it's a really interesting problem. And certainly I think the way in which these committees are set up are to me, like, that's the biggest issue. If you set up a committee that is essentially designed to be an industry voice, whatever it comes out with is going to be industry voice. But that is not always going to be apparent to the public. Like, you have to dig deep before you understand that the National Farm Animal Care Council is not a government organization. Because when you look at it, it sure looks governmental. It's got a lot of glossy governmental publication look to it. And like, they want to talk about themselves as an umbrella group of all the stakeholders. It's only when you dig deep that you see that there are some flaws in the way this representation takes place.
Well, it sounds like one of the key stakeholders, indeed arguably the biggest stakeholder, the animals involved, are not well represented. So perhaps that's a challenge for their marketing team if they want to be a bit more honest in their description.
Always a concern. We got to teach those animals to talk, and then we'll be on to something.
That's right. Now, Peter, I ask everyone who comes on the podcast to answer 5 quick questions. Are you ready for your 5 quick questions?
I'm ready. Go for it. I hope I can answer them well.
Can you recall the first piece of pro-animal scholarship you ever read?
I wish I could. It's been so long. I really thought about this, so I'm going to throw out a couple that may have been it, okay? Because I can't remember. It's either Stephen Wise's Rattling the Cage, because this would be around 2001, and I think that book was pretty close to just coming out, or it would be Introduction to Animal Rights, Your Animal or Your Dog by Gary Francione. When I started, there were so few sources for animal law issues, and I'll be honest, I'm a law scholar, so I'm not sure. I can't even remember how developed the field of animal studies was at that point, but I was most interested in the legal issues. And there just was almost nothing. So I found those 2 books really, really interesting, and they helped galvanize my interest in this area.
Wonderful. Well, can you recall the first piece of pro-animal scholarship you ever wrote?
That I do remember. That was in 2002. It's like an era ago. And it was a very short commentary. It was about a 5 or 6 page article, and it was about sentencing. It was about sentencing in animal cruelty cases, and I wrote it for the New Zealand Law Journal, and I was concerned about the way in which these sentencing cases, which was happening at the time, were not taking into account the harm that had really been done to the animals. They were approaching it on a very contractualist basis, which was sort of looking at the overarching harm. And I found these sentences were focusing really exclusively on the moral wrongness of what had been done. And I felt that they were misunderstanding the way in which suffering actually was endured. And I think they really undervalued the extent of the harm to a really vulnerable being. So like even then I was trying to, get people to think differently about the nature of the harms, which is still such a big problem. Even today in the criminal law, I think it's better than it was then, but I think we still undervalue the extent to which the animals matter in the bigger picture.
Certainly still sounds relevant. Well, Peter, if you had to name one animal studies scholar who's had a big impact on you, who would it be?
This is a tough one for me, and I think it's more a reflection of being around for so long, in the sense that a lot of the people when I was starting, when I really needed that inspiration, most of them are either no longer around or they've evolved or I've evolved to the point where I don't rely upon them. So I'm going to throw out a name. I really liked the work. She doesn't do as much work in this area anymore. Her name is Tammy Bryant. She's a professor at UCLA. And I really liked her work. I thought it was really thoughtful. She was one of the first professors in the US to publish in mainstream law journals about animal topics. And I found her work was really interesting. She looked at stuff from a really different perspective, really trying to create almost an animalist perspective in the area of law, building on a lot of feminist theory and others that were trying to look at animals as others and what that meant for the laws that effectively laid out how they were going to be treated. So I found her early work in this area in the early 2000s when I was just getting into my own sort of thinking about what I wanted to do in this area. I found it really meaningful.
Wonderful. Well, that's fantastic. A fresh name on the program. So, Peter, what's the most important thing academics can do for animals?
I always say the same thing when I'm talking about legal academics, and I don't think there's enough of us doing it, is I think that I think we have to consistently explain to the public why the law doesn't work to protect animals. In fact, that's the name of one of the books I'm working on. Like, I just think that there's a disconnect between the public and understanding that the government, at least where I live, but frankly in most areas of the world, has effectively abdicated its role in enforcing or even revamping the laws governing animals. I mean, that's not true everywhere, and I know there are some jurisdictions that have done this, but I think that, like, as a legal scholar, I've always thought it was my role to explain why the law doesn't do what people think it does, because that's the biggest thing. And in one of the chapters of this book I'm working on, you get this, I have this sort of dialogue with the imaginary person who's watching all these things. If someone harms an animal, they're going to be prosecuted. I know that because, somebody hit that dog over there and the police came and they looked into it, and trying to explain to people why the law doesn't work the way people sort of have this inkling that it works, because I actually believe, I'd be curious on your views of this, but I actually believe that, like, the average person, knows that animals are treated badly and they know that the agricultural process isn't great. But I actually believe that to a certain extent, to the extent they think about it at all, they do think that the law is designed to really reduce suffering and really make sure that it's, just the bare minimum, like no more than is absolutely necessary. And like trying to explain why the law doesn't actually do that and explain how the loopholes that exist, which is why, like, the number one talk that I've given around the world and I've been giving it since 2005 in a variety of different forms, and I must have given it by now about 25 different times, is sort of explaining why animal welfare law doesn't actually protect animals, and trying to explain how the many, trying to show that there are like 6 or 7 different major loopholes that exist is to me what academics have to do. I think all the other interesting things that we do are important, but I do think that the biggest thing academics can do is continue to act as a conduit for the reality of what our laws fail to do, and just continue to explain that over and over again in every forum that we can.
Interesting. Wonderful. Good on you. Well, Peter, if you had the power to change one thing about human, non-human animal relationships, what would it be?
Wow, what kind of power do I have, Siobhan? I'm like, that is absolute power. I'm trying to decide how big to think or how realistic. And my brain is always like, I should go for something realistic, but I kind of want to just say, break the chains. If I have that power, right, I'd make them talk and overturn, but that would be a major revolution. So maybe I shouldn't do that. Okay, if I had the power to change one thing, I'm just going to pick a couple of easy things in the legal world that I actually think are quite attainable. And one of the easiest things I would do is give humans standing to act on behalf of animals and advance their interests in court. That is such a major problem that we have here, in that it is, even where we find the mistreatment of animals on a major scale, the legal system refuses to allow us to actually get in there and do something about it, simply on the basis that animals, as an item of property, do not have the legal status to be represented in court. And I would just abolish that tomorrow and say, no, we need to recognize that animals are vulnerable. We owe them a duty. They are in our care, and we cannot just trust their owners to act on their best behalf. So we have to be willing to grant organizations and other groups the standing to get in there and try and make a difference. And in Canada, we're constantly facing this problem. Every time we try and find a different way into court, we get bounced out on the basis that there's no standing. It's an abusive process. Only the government can act this way, and the government doesn't act that way. We all know it. So I would say, no, get rid of those ideas. Get rid of all the procedural loopholes that say that, people cannot act in the best interest of animals in the courts, and allow them to get into the courts, and then we'll deal with the merits of the situation. Do these problems actually merit intervention of the courts? And I just think that's essential. So that's the power I would give to allow us to have hopefully some gradual change.
Fantastic. Well, Peter, I know this is going to be a very big question for you, but what are you working on next?
I'll pick the short one. I'm working on, believe it or not, just a pretty basic text. I'm working on 2 books consistently. One is for the general public about, how animal protection law fails to protect animals. But I find I rarely have time for that book because it's such a huge project. So it just keeps getting put off on the back burner. But I am now working on a basic framework on Canadian animal protection law, because there is not, at this moment, a text that people can turn to understand what the law is. So this book for lawyers will be an attempt to explain exactly how Canadian animal protection law works and go through the emerging jurisprudence on federal and provincial animal cruelty issues.
Wonderful. Now, Peter, we haven't yet touched on your podcast, which I definitely want to make everyone aware of. So this is the part of the show where I say, where can people find out more about your work? But in answering that, can you also tell us a little bit about your podcast?
Sure, because that's one of the best places to find out about our my work. So I do a podcast called Paw and Order, which is a play on the American show Law and Order, and it's all about the law governing animals in Canada. And it's a pretty fun podcast I do with my co-host Camille Labchuk, who's the executive director of Animal Justice, which is an advocacy group in Canada. And we every 2 weeks we do a podcast on a number of interesting topics. We have guests on. I believe we had a guest on our last show. I think it might have been the host of this podcast, Siobhan O'Sullivan. So it's great. It's a really fun podcast. I've enjoyed doing it. We've been doing it for about 2.5 years now, and we don't have as many episodes as Knowing Animals, but we're getting up there, and I'm really proud of the work we've done on that show. So Paw and Order is one of the ways to learn more about my work. I would say the other 2 main venues are, I have a website, petersankoff.com. It's just my name. You can find out all about my work. There's a whole section on animals there. I've done a lot of videos where I go through Canadian animal law in some detail, and you can find those there. And the other best place to find me is on Twitter. Peter Sankoff is my handle.
Indeed, and I follow you on Twitter. Well, Peter, thank you so much for joining us. And thank you to the...
My pleasure.
And it was wonderful having you. It was great that we could have this reciprocity in podcasting. And a big thank you to the listeners for joining us for Knowing Animals, the podcast where we talk to animal studies scholars about their work. And you can also follow us online. We're at Twitter at knowing_animals. There's a Knowing Animals Facebook page, a Knowing Animals Instagram account. And finally, don't forget to leave a review at iTunes. Reviews make it easier for other people to find us. I'm Siobhan O'Sullivan, and I do like knowing animals. For more great iRaw podcasts, visit irawpod.com. That's IROARPOD.com.